oyez, oyez. The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning. Reminder that unless the court has put an order down to the contrary, saying otherwise, oral arguments are live streamed on the AOC site and then will later be posted on the AOC YouTube site. So whatever is said or happens in here today is there for posterity, I guess. Call the first case, please.
Yes, Your Honor. State ex rel. Adolphus Pelley v. Perkinson.
I'd like to reserve at least 3 minutes for rebuttal.
We'll hear from the appellant.
Good morning, Your Honors.
Good morning.
May it please the court. Dr. Adolphus Pelley has served on the Athens City Council for a quarter of a century. He's been elected, re-elected, re-elected, and re-elected. Now, up until recently, his time serving was relatively typical until Bo Perkinson was elected mayor. Now, in Athens, the mayor is the chair of the city council, which means he decides what happens and in what order and how. Now, the city of Athens years ago adopted Robert's Rules of Order as its procedure for city council meetings. After Bo Perkinson was elected mayor, Dr. Pelley was not allowed for over 2 years to present a single motion. He was cut off in discussions. He was not allowed to speak. He was not allowed to debate. And so he contacted me, asked me to file this is exactly the kind of thing that the Tennessee ouster statute was written for. When a person is in elected office and their office has rules and they're not following them, that's what the ouster suit is about. I wrote a letter before I filed the ouster suit. I wrote a letter to Dr. Pelley's attorneys, point citing Robert's Rules of Orders, the sections that specifically said the things he was doing was denying Dr. Pelley his fundamental rights as a member of the council. Nothing changed. So in June of 22, I drafted this, I talked to Dr. Pelley. As the court understands, in Tennessee, the ouster statute requires a representation of at least 10 people, citizens in the jurisdiction, in order to bring an ouster suit if it's not the DA bringing the suit. I told Dr. Pelley this, and I'm certainly not going to trust any client to tell me that, yeah, I've got 10 people. So I drafted the simplest declaration I've ever drafted for the sole purpose of creating an attorney-client relationship between myself and the people Dr. Pelley claims were supporting him in this ouster, the realtors, or relators. In any case, that declaration simply says, it was a form declaration, and on page, the language appears on page 6 of our reply brief. It's a form declaration. You fill in your name, you sign it, you date it, and you put your address there. Now, the address was simply to verify that they actually lived in the jurisdiction. The entire point of the declaration was simply to establish that they lived in the jurisdiction and that they were willing to participate as a relator, a freeholder in the case. That's what it says. That's all it says. It doesn't say anything about an August 16th council meeting, and it doesn't say anything about any of the other facts set forth in the petition. Now, it does have language that says, I have read and agreed with all the facts set forth herein and have personal knowledge of same. Now, that was language that I had put in every declaration I drafted up till this point, simply to establish that whatever the declaration was about, the person actually had personal knowledge. Unfortunately, the court took that to mean these were all verifications. As this court understands, the ouster petition has to have a verification. Well, the only person who had knowledge of all of the things that happened over the 2-year period was Dr. Pelley. On page 5 of our reply brief, there's the language of the verification. Now, the verification was integral It was part of the pages of the petition. It specifically said, I have reviewed each factual allegation set forth within this petition. Dr. Pelley was the only person who verified because only one person was necessary, which the court, in finding that I committed fraud after practicing for 20 years, that I committed fraud on the court intentionally, one of its factual findings was that the declarations couldn't possibly be legitimate because they were signed in June of 22, and the petition talks about an August 16th meeting. After I had begun this process, I went to the August 16th meeting. I just sat and listened to the whole thing. And then I drafted the petition. The petition explicitly says this has been happening for 2 years. It says that repeatedly, all the meetings. But I talked I talked a bit about the August 16th meeting because I knew what had happened exactly. Well, the circuit court judge, Judge Sharp, again, factually found that those declarations were actually verifications and that they were fraudulent because they couldn't possibly have known about the facts of the August 16th meeting. They were never intended to. They don't say that. The declaration says, I have read and agree with the facts set forth herein. Now, Webster's Ninth Dictionary defines herein as literally in this document. This document, a separate declaration, 1 page, that I handed 20 blank versions of to Dr. Pelley. This is a clear error. It was never my intent to have those verifications, and the most important thing is they don't claim to be. And yet the court is insisting that that's the fraud, that's the bad faith. The circuit court also erroneously found that I didn't represent some of these relators. So what happened was they signed the declaration, apparently not reading it. Opposing counsel asked for, and as the court knows, in ouster suits, time is of the essence. A new election was coming up in a few months, and we wanted to get this taken care of. At the end of the day, Judge Sharp says, this shouldn't have happened, this whole case shouldn't have been brought, we should have waited for the election. Dr. Pelley had been elected over a half a dozen times, and this was still happening. This wasn't about the election, this was about one mayor not following the rules of procedure, being warned about it, and still doing it. Judge Sharp factually found, in his order sanctioning me and finding me guilty of bad faith against the court, he factually found that I didn't represent certain people who had come to the depositions and said, I've never met this guy, and he doesn't represent me. The problem with that is the court in Jackson in this state established that there's 2 elements to creating an attorney-client relationship. One is that the attorney is offering to represent, and 2, that the client accepts, or vice versa. The point being there has to be a meeting of the minds and an agreement. That's why the declaration was drafted the way it was. I wanted to establish in writing, under penalty of perjury, that these people were serious about supporting the ouster. That's why the declaration says, and I'm willing to support this ouster. According to Jackson, I had an attorney-client relationship. Now, what happens if a party signs a contract and then comes to court and says, oh, doesn't say, yeah, I signed the contract, but the contract's not, that's not me. I don't agree to that contract. Well, it's too late, you already signed it. Now, they certainly had the ability and right to fire me, and they did, or, mutually changed relationships at the deposition. The depositions happened so fast. As soon as the petition was filed, I was pushing for an initial hearing, and opposing counsel asked for depositions. I think it was about a week later. I made a darn good attempt to get 20 or 18 people. It turned out we had 18. I had asked him to get 20. He got 18 just to make sure we had the 10 that we needed. I got at least 10 or 11 of them to show up during the middle of the week, during the middle of the day for depositions. I could have said no, I didn't. I was trying to be transparent, like I always have been. But we showed up for these depositions, and these people were, some of them were saying, I don't know this guy. I've never met him, he doesn't represent me. Is that your signature on the declaration? Yes, it is. But I don't know him. Well, big firms have non-lawyers do intake all the time. Often a lawyer at a firm never even meets their clients. The fact that, and the court made a big to-do about the fact that these people testified they had never met me, and I didn't represent them. Well, I may not have represented them after that fact, after they stated that, but I certainly did when I filed the petition because I had their declaration saying I did. Now, the only evidence presented at the initial hearing was Dr. Pelley testifying. It's the only evidence presented. He testified at length about how he had been prevented from bringing a single motion for over 2 years because of Mayor Bo Perkinson. There was some cross-examination, but the evidence was not really contested, and unfortunately, Judge Sharp said, well, you haven't made your case. I don't know what else we could have done, but we didn't make our case. And then when I saw what was going to happen at the trial, I mean, nothing was going to be different. We were presenting the same evidence. I non-suited because I saw how this was going. Now, the statute that's being asserted, one of the statutes that's being asserted is attorney's fees may be granted pursuant to Rule 11. Well, I never got a letter, and we had already non-suited the case. And in fact, the statute actually, I believe, says that the judge can do a show cause order before the case is dismissed. That didn't happen. So procedurally, there were problems with my sanctions, but primarily, this comes down to a misunderstanding by the court that I have tried to explain, just like I have this morning, multiple times. And apparently, unfortunately, the circuit court is unable to understand what I'm saying. These issues have never been addressed. Jackson has never been addressed by opposing counsel or the court. In fact, I got Jackson. I take that back. The court had Jackson. That's why I went back and read it. But the Jackson precedent establishing that I actually did have an attorney-client relationship with those people has never been controverted. Going to reserve the rest of my time for rebuttal. And do your honors have any questions for me?
I hear none, and you've got your 3 minutes for rebuttal.
Thank you.
We'll hear from the appellate now.
Good morning. If your honors please, I'm Danny Rader from Cookville on behalf of Mr. Perkinson. This, of course, the appellant who argued today was Mr. Van Arian. Mr. Van Arian is an appellant himself. The brief that was filed by an attorney, Russ Egley, stating that he was filing that brief on behalf of Mr. Arian. But none of the brief nor any of the argument today was about the sanctions against Mr. Pelley. And I don't know that Mr. Pelley has perfected an appeal. I don't know if he's filed a brief. I don't know if Mr. Arian is purporting to represent Mr. Pelley today or not. All I heard Mr. Arian talk about were, quote, my sanctions, the sanctions against him, the actions that he took. But the trial court found that Pelley and Arian acted in concert and should both be sanctioned, and the judgment is against both of them, and we hope that this court will affirm that. This concept of who Mr. Arian represented in the trial court was like a game of whack-a-mole. The original petition does say that Mr. Arian represented all of the relators, the individuals who signed these declarations. It was very clear that it said their attorney, plural, Mr. Arian. And today he admits that he represented them at that time. In the depositions, though, at least 9 of the people, maybe more, certainly more that would get the number under 10, said that they'd never seen him before, never heard of him, didn't know who he was, that he wasn't their attorney, that they didn't have an attorney, Carla Arterburn was one of the relators. She hand wrote out a non-suit for herself. If he represented Ms. Arterburn, he should have prepared the pleading for her.
The document that they signed, did it state that they wished to be included as one of the 10 or more individual freeholders required to file the above entitled petition?
All of those individuals signed that declaration in blank that does include that sentence.
Was that on there when they signed it? I mean, I read
That sentence was on the declaration when they signed it. What it didn't refer to was an ouster. And so what the individuals said was, we didn't, for instance, Brenda Seinkoff, I quoted her testimony in my brief. She said, I didn't know this was about an ouster. Nobody told me this was even going to be attached to a lawsuit. The petition, the scheme, Jonathan Bryan Key testified, and I quoted his testimony, would respectfully submit that the scheme worked, that Mr. Pelley would represent to the individuals who signed that they were just signing a petition in the conventional political sense to give him more speaking time. Many of these folks did not understand that this was to be attached to a legal petition. Many of them certainly didn't understand that it was being asked to oust the mayor of their community. Many of them, I think all of them, as a matter of fact, said that they didn't know of any facts that would support an ouster. And of course, as the court knows, an ouster is not to be used for political inquisition. So the declaration not only misrepresents the nature of the case to these individuals, misrepresents the nature of Arian's role, but it caused people to sign on to a lawsuit and be exposed to attorney's fees and costs and other consequences that they didn't even understand that's what it was, and no one gave them the opportunity to understand. And the petition itself that was eventually filed relates to facts that occurred after those declarations were signed. All of the ones that are dated, many of them aren't dated at all, but all of the ones that are dated before the events that formed the basis for the lawsuit. And when
I thought he said that this has been going on for a number of months and that the petition referred to that.
That's what he says, and there is some vague reference to that kind of sentence in the petition, but the vast substance of the petition relates to an August 16th meeting. And what the testimony came in was that Mr. Pelley, his client, had a scheme planned for that August 16th meeting. He was going to bring up, he said, either 27 or 37 motions at that August 16th meeting. And he was going to move to fire the city manager, move to fire the city attorney. And he was going to just derail the city council at this meeting. And of course, he knew that that wasn't going to be allowed to happen. The other city council people, he made points of order and they voted him down, which is their right to do. So that's the petition then that he filed, having already gotten these declarations. 2 days after the August 16th meeting is when he filed this petition on August 18th. So that's what Judge Sharp found, that Pelley and Arian acted in concert to perpetrate this fraud on the court in multiple ways. The fraud has continued, though, in his response to the motion for sanctions in the record at page 450.
Let me take you back a second, excuse me. So you talked about the alleged fraud on the court was filing these declarations dated earlier, and in the declarations itself it referred to the August meeting.
The declaration doesn't mention the August meeting, but it says
But the petition does.
The petition is nearly all about the August meeting. The case was all about the August meeting. When we had the hearing, the videos of the August meeting formed the substance of the evidence. That's what this lawsuit was about. Because Pelley knew that he was going to do that at the August meeting and make this about that.
So the trial court found that declarations dated earlier
Misrepresented.
and the petition dated later, which were all filed with the trial court,
Right, together.
were an attempt to defraud the court.
Yes, sir. And
Not a very hidden attempt,
No, it was not very hidden, and we didn't know, when we first got the suit at the 1st of September, just exactly how bad this was, and we took these. When we got the suit, Mr. Arian had already had an ex parte discussion with Judge Sharp and obtained an immediate hearing date because the ouster statute has that provision to have emergency and urgent hearings. And so we immediately tried to schedule these depositions to find out what this case was about. And that's when we discovered the fraud, 1-2 days before this hearing.
You couldn't discover it by looking at the dates.
Well, we didn't know, most of them are not dated. Only 6 of the declarations are dated at all. And so we didn't know that they had all signed it earlier. We knew 6 of them had that problem and obviously planned in the depositions to discover that. But it's multiple levels of fraud, and he's persisted with that fraud in this court. So in his response to the motion for sanctions in the record at page 450, Mr. Arian stated about himself, quote, "He does not and never did represent any of these relators." Obviously today he says that he did represent them. In the petition he says that he did represent them. In the reply brief that he filed before this court on page 13 in footnote 2, Mr. Arian addresses this quote, he does not and never did represent any of the relators, and tells this court that that statement is taken out of context, that it doesn't really mean what it says. So I looked back at the record at page 450, and I hope you all will too. It says exactly what it says. There's no possible misunderstanding about that language. He told the trial court he didn't represent them. Then he told the trial court that he did represent them. And he's taking these alternate positions because he got caught and was in trouble. And it's a continuing, ongoing fraud, which is why we filed our motion to ask the court to consider post-judgment facts. As the court knows, the only proper use of ouster suits is for severe malfeasance. The state ex rel Plemons case says it's got to be for conduct that's indictable. It's not to be used for a political hit job or political inquisition. This is exactly what this was, timed to be filed during the process of an election in Athens and to try to influence that election. And unfortunately, they got away with that. Mr. Perkinson, my client, did not win the election, probably because of the media coverage associated with this ouster. Most people don't know what this is about, Robert's Rules of Order, or any of this fraud. All they knew is that there was a serious trial hearing to try to remove the mayor from office. And they got away with that. The law provides a remedy for this kind of wrong. Unfortunately, I don't think it's severe enough, but it is a clear remedy, and that's this TCA 8-47-122B. It gives the court the power to award attorney's fees and costs. The trial court did that here. That statute is broad. It says notwithstanding any other law to the contrary, it would override any non-suit or any other thing like that. Mr. Arian halfway tried to argue that in his brief but didn't raise it as an issue. Mr. Arian claims that statute only authorizes Rule 11 sanctions and talks about not getting a letter. Again, from the time this lawsuit was filed and we were hired the 1st of September to the time of this immediate hearing that he'd obtained ex parte, and the final trial date was 18 days total. There was no opportunity to send a safe harbor letter under Rule 11, but this statute does not require one because it allows the award in 3 contexts. 1, if there's Rule 11 of the Tennessee Rules of Civil Procedure. 2, if the complaint or petition is withdrawn, which this was. Or 3, if the court finds the charges are alleged to be without merit. So 3 different circumstances. The latter 2 of the 3 certainly are the case. We submitted to Judge Sharp he could issue Rule 11 sanctions on his own motion, but he chose not to do that and proceed under the statute. I think the statute clearly allows that. Mr. Arian's reading of the statute is wrong when he says that it's limited only to Rule 11. I've discussed in the brief the Oxford comma and the grammatical structure. This court has addressed that before in White versus State Farm, and how the court is compelled to follow these grammatical constructs when interpreting a statute. A coordinating conjunction, the or here, whether there's a comma or not, joins 3 grammatically equal elements. So this principle is well settled. If it's confusing to a middle schooler or even an adult like me, that doesn't mean that it's not well settled and it's not clear, the law. The court also found that Mr. Arian should personally be sanctioned and made the judgment joint and several with Mr. Pelley. The court did that under its inherent power of the court. The Supreme Court has authorized that under the Andrews versus Bible case. That's allowed. It's an even lower standard than the overt fraud that the court found. Of course, Judge Sharp found that this was a fraud upon the court, but Andrews versus Bible allows it when there's bad faith or reckless conduct. Reckless, of course, is bad, but it's not intentional fraud. This court found that at a minimum it was bad faith or reckless. At its maximum, it was clearly fraud. The court found that in numerous circumstances, the court has discretion under the law to impose those sanctions against the attorney himself, Attorney Arian, and did so. This was an abuse of the civil justice system to try to influence an election. The ouster suit should never have been filed for something about how does a meeting get conducted, because that's not an indictable offense. It was obviously done in a fashion that was intended to perpetrate a fraud on the court and allowed that to be furthered, and unfortunately it was successful. If the civil justice system doesn't have the ability to defend itself from this kind of abuse, then there really is no limit. And that's what the motion for post-judgment facts is about, is that even in the face of this sanction award, subsequent to this judgment, this same attorney has continued this same pattern of misconduct against my same client, Mr. Perkinson, just in the federal district court. And we'd ask the court to consider those judgments from the federal district court post-judgment matters, because they are, quote, judgments or proceedings, which is allowed under the Appellate Rule 14. And we think it's important because the sanction that the trial court imposed here didn't go far enough. We actually asked the trial court to suspend Mr. Arian from the practice of law. The Davidson County Circuit Court did that with an attorney, Brian Manukian, for some reckless conduct in a case over there involving attorneys C.J. Gideon and Philip North. We asked Judge Sharp to do that. In this case, he didn't. He just imposed the monetary sanction. Of course, I don't think this gentleman can pay it. I don't think he ever will pay it. I think it's just a statement in the ether. But the civil justice system has to defend itself from this kind of misconduct. And I hope that this court will go farther to impose further sanctions against Mr. Arian and Mr. Pelley, either under frivolous appeal or the inherent power of this court, or TCA 8-47-122, and we've asked for all of that in our brief. With all due respect, this is probably the worst case that I've ever seen in my time of practicing law. I don't know how the court can not vindicate this wrong, particularly when they were likely successful in their political hit job, and the mayor losing, who had been on the council for over 20 years, losing re-election. Mr. Arian, in the post-judgment facts, has sued the Eastern District Court that sanctioned him. In the Middle District of Tennessee, has sued the Eastern District of Tennessee, the court itself. There's no reason to think he wouldn't file an ouster suit against Judge Sharp. There's no reason to think he wouldn't file an ouster suit against you all. There has to be a remedy for this kind of wrong, and we hope that this court will please impose one. Thank you all.
Thank you. Hear from the appellant in rebuttal.
Your Honors, Mr. Rader stood here and stated to you all, the declaration misrepresents the nature of the suit. Now, on page 6, the declaration language says, as a resident of the city of Athens, Tennessee, it is my desire to be included as one of the 10 or more individual freeholders required to file the above entitled petition pursuant to TCA 847-110. I don't know how I could have been clearer about what was going to happen. The above entitled, the declaration it had the title heading. It had ex rel Pelley versus Bo Perkinson. It had the case title and what court it was going to be in right there at the top of it. He also said that the vast majority of the petition was about the August 16th meeting. The petition asserts 7 paragraphs about the August 16th meeting out of 52 total paragraphs. That is not the vast majority by any stretch. It also says, for over 2 years, the city of Athens has refused to include any agenda item requested by council member Dr. Pelley. The court finding that the declarations I drafted were about the August 16th meeting is clear error. And it is the foundation and basis for its sanctions against me. I also had no motive.
Let me ask you, just to clear something up for me, exactly who are you representing today?
The issue of who I was representing, the out-of-context statement to the court, the ouster statute can be read that once you have the realtors and you file the case, you actually represent the state of Tennessee, because what's happening, and that's why the DAs usually bring these, but in a case where the DA refuses to, as in this case, we have the statute allows us to bring it as citizens. The statute, I read it carefully many times before I filed this. I hadn't done one before, and it certainly looks like you represent the state of Tennessee as the petitioner. I took that, and that was what that discussion was about. Clearly, the realtors, I mean, this case ended up...
Well, let me go back to my question.
Sure.
We're here on the appeals to sanctions and attorney fees, correct?
Yes.
Who are you representing today? Just tell me who they are. Yourself?
I represent myself and Mr. Pelley. Our interests are aligned, and I've discussed this with him, and I represent him.
All right. Okay. Your time's expired. Thank you.
Thank you.
We appreciate your arguments this morning and your briefs in this matter. We're going to take a short recess to do a judge change. So if you would, recess court for...
All rise.